So moving on to acceptance, this can be defined as unconditional agreement to all terms of an offer by words of conduct. So the basic rules are that the acceptance must be communicated to the offerer, and it can't be silent, like if felt out and blindly. You know, if I hear no more from you, then I assume we've completed the contract. It can be in any form, so written, verbal conduct, for example. We explained what they are before in offer. If the offerer insists on a particular method of acceptance, then that must be used. So if they want a letter, they want an email, they want a phone call, then it must be used if it's mandatory. And Yates and Perline tells us this. And acceptance must be unconditional, as we've seen before. But of course, be aware that a request for information is not a rejection. It could be acceptance with a further request for information, for example, for credit terms. Note, I'm not put the postal rule in here, and I don't intend to discuss that in terms of application, because that's not the normal way of doing things now, so it's unlikely to be a problem question. It could be underpinning knowledge, of course. What is more likely is that there is a more modern method of communication. Now this could be a problem usually is where it's out of hours. So if an out of hours message is only effective once it's opened, you know, like a Brinky Boy and Stahag style. And email acceptance is acceptance if it's sent at a reasonable time. So for example, if the course of dealings indicate that 6:15 is usually an okay time to send an email, then it will be acceptance.